Good morning, everyone. This is Navneet Chugh. Thank you so much for attending our webinar today. Unusual that we hear some good news regarding immigration and green card deadlines. We've received some exciting news last week as the immigrant visa cutoff dates for many employment-based green card preference categories advanced significantly last week. This means now many foreign nationals can file for adjustment of status to get their green cards, particularly Indian nationals in the EB3 category, advanced 5 years from 2010 to 2015. We have a great talented panel of experts here today with me to answer your questions regarding adjustment of status, regarding downgrading from EB3 to EB2, since EB3 is now ahead of EB2. I have three of the most wonderful immigration professionals in the country: Dia Matthews from Edison, New Jersey, Carmen Lopez from Los Angeles, and Deepika Singh from Santa Clara. My pleasure to have them with me today. So to begin with, let's get an overview, a 30,000 feet view of what is really going on and what is the situation right now, and why this is such an important move and a moment for all of us. So Carmen, can you tell us what's going on?
Sure, sure, no problem. Thank you so much. Can you hear me?
Yes.
Okay, great. Well, thank you so much. I'm excited to be on this call today to give you some information. Exciting times, you know, we haven't seen a movement like this since 2015. I wanted to first give you a little history regarding the visa bulletin and how it became one table to two tables. To begin, in September of 2015 and before, there only existed one table for employment-based and family-based cases. Therefore, if your priority date was mentioned in the visa bulletin prior to the date posted in the bulletin, you could file your I-485 application for adjustment of status for you and your family members, which include your spouse, children under the age of 21. This table is called Table A, Final Action Dates. However, in October 2015, Department of State added an additional table. This table is called Table B, Dates for Filing Employment-Based Visa Applications. This table was added for purposes of filing an application in order to obtain an EAD, known as an Employment Authorization document, which would allow you to work, and advanced parole, which would allow you to travel. However, you cannot simply just use this table because your dates are current in this table. You have to use Table B, and USCIS has to tell you which table to use. So it's not like you see the table A and B and you see it in B current and then you could use it. USCIS has the last say of which table to use. Typically, by the early part of the third week of the prior month, you can see the next bulletin for the following month. For example, in the third week of September, you can typically see the bulletin for the following month, and that way you can plan how you're going to file your I-485. On the bulletin itself, there's a link that connects you to the USCIS website where you can check which table to use. Now, as Mr. Chuk said, two things of significance have occurred in the month of October. First, in this month of October, USCIS states we can actually use Table B, Dates for Filing of Employment-Based Visa Applications, which is rare most of the time, because most of the time they want us to use Table A, USCIS. Second, in October 2020 Visa Bulletin, there has been a significant advancement of employment-based categories. For example, for India-born nationals, second preference, known as EB2, it has moved from August 15, 2009 to May 15, 2011. And for third preference, known as EB3, it's moved from February 1st, 2010 to January 1st, 2015. And other certain countries have become current for all employment categories. Back to you, sir.
Navneet, I think you may be on mute.
No voice.
Yeah, sorry about that. I was on. So Deepika, let me ask you, so who is now eligible for adjustment of status in October 2020?
Thank you, Navneet. A very good question and very important question. Being very specific to employment-based eligibility, a person who has an EB1, EB2 or an EB3 I-140, either approved or in process with a priority date meeting the filing dates as per the USCIS visa bulletin under table B can file a 485 application. If you are filing an adjustment of status, you need to make sure your underlining non-immigrant visa is dual intent like the HL and also for your dependents. If your visa category is not the H and L, you need to speak to an attorney and check on your eligibility. That's very important. The other part is that if you are not physically present in the US, you cannot file an adjustment of status. So to file a 485 application, you have to be physically present in the United States. Any derivative applicant who is a child of the principal applicant under the age of 21 or is turning 21 should seek guidance with an immigration attorney to discuss the eligibility, because there could be some restrictions on filing the 485 applications. The other important part to note would be that for filing, you need to consider 1 day before the date mentioned on the visa bulletin. And these are the most important things which you have to remember when you're filing a 485 application. Over to you, Navneet.
So this adjustment of status, Deepika, how does it work?
So every month, Department of State releases two visa bulletins, which Carmen just mentioned, Table A and Table B. Table A is more for the final action dates, meaning the visas being processed, the green cards being processed for that priority date. And Table B is more for referring to the application filing dates. USCIS confers every month which bulletin to use for filing of the adjustment of status applications. Anyone who's doing consular cases, they have to move with Table A dates. They do not follow the Table B. For AOS filing, you have to make sure that there are some specific forms which have to be supported in the application along with some supporting documents. Now, just to give an overview of what goes in an AOS petition. First, a G28 if an attorney is representing you. Then there is a 485 application, which is the form to register permanent residency. So that's a 485 form. There's a 485J, which is for the green card, which the employer is supporting and sponsoring. There's the I-944, which is the declaration of self-sufficiency. There's the I-131, which is the advanced parole, and the 765 form, which is the EAD. Now, the important specific point of each form is that the I-140 being used to file the 485, that has to be supported by the 485J. What I mean by this is that the I-140 employer and the 485J employer has to be the same to file the 485. And this basically means that the employer who's signing the 485J and has the I-140 approved for or in process for is supporting your 485 application for either for the green card application. Now, you have to remember that the 765 and the I-13 forms are optional. You don't have to file an EAD application and an advanced parole application at this point of time. You can file it later on. Basically, the significance of the 765 is that it gives you an EAD to work with any employer after you are eligible to port to another employer. There is specific requirements for that. And the I-131 advanced parole, which you can use if you move to an EAD to travel in and out of the United States without getting any visas for a non-immigrant category. The 944 is basically a declaration of self-sufficiency, which is more like a financial health check. It does require a lot of your information about your assets and whether you have medical coverage, what is your education, and it is to be submitted for each applicant who's filing the adjustment of status. Now, there is a news of an injunction of no fee increase. Earlier we were known that there was going to be a fee increase for fee decrease for the 485, but a fee required for the 765 and the I-131. But looks like there is an injunction, and most probably there will be no fee increase for the 485 applications. But we are yet to hear from USCIS and confer on that information. Over to you, Navneet.
So before you run away, Deepika, let's talk about the interview process. Will there be an interview, and what can I expect when I go for my interview?
So yes, there will be an interview process. I mean, USCIS has said that they would be scheduling interviews for the AOSs, depending upon whom they want to do it for. But that will only happen once the priority date of the person comes closer to the table A dates, and it will not happen during the course of action when you file the application till your priority date becomes current as per table A. So the things which you can expect on the interviews could be anything related to your employment, anything related to your statuses in the United States, all the non-immigrant statuses you've maintained. Typically, they can question you anything related to your education background, the kind of work you do, what is your current employment, who have you worked for in the past. And we would recommend that every person is prepared with such questioning at the interview stage by the immigration officer.
Okay, thank you, Deepika. So let's go to Carmen in LA. So Carmen, I'm working and I also want to travel. What should I do while my I-485 is pending?
Yes, that's a good question and a very common question. When an I-45 application for adjustment of status is filed, the foreign national can concurrently file an application for employment authorization and for advanced parole. Pre-COVID and this rush, these applications for EAD and AP would typically take about 4 to 8 months to approve and use. Now it may take even longer, obviously. If the foreign national has an underlying status, such as an H-1B, for example, it is recommended that they should not continue to use, they should continue to use, their H-1B to work. Now, once the EAD is approved, they can use the EAD instead. However, when they use their EAD, they forego their H-1 status upon using the EAD. It's effective immediately. If the I-45 is denied, foreign nationals would be left with no status. So the same goes for the dependents. If the H-4 uses an EAD, they forego their H-4 status. However, if the EAD is not used, they will continue to hold their H-4 status or ever underlying status. It's H-1, any status they have, like L status, for example. They'll continue to hold it even if the EAD and advanced parole were issued. As for the advanced parole, in my opinion, it is very valuable. I believe that really, filing this I-45, the most valuable part is actually getting an advanced parole. Why is that? Well, because once the advanced parole is issued, they can use the advanced parole to leave and re-enter the US without the need to obtain an H-1 stamping or H-4 stamping, and still be able to continue to work on the H-1B upon entering the United States if their H-1 status is valid. The family does not have to enter together. They can enter at different times. So, you don't have to worry about that. If you have an advanced parole, when the spouse can enter first, or the, H-1B, H-4, it doesn't matter. Now, it is important to note that one should not travel while the advanced parole is pending, as if you travel while it's pending, the advanced parole will be denied. As for the employment authorization, you must be physically present in the United States when the EAD application is filed. However, one can be outside the US when the EAD is approved. However, you should not travel until the advanced parole is issued. They normally are approved as a combo card. So when you file the I-485, you will be submitting the EAD and advanced parole applications together, and USCIS will then issue a combo card where it's typically valid for a year and renewable every year thereafter. Now, there is a way to get emergency travel document if there is an emergency and you can't wait those 8 months, 9 months, maybe even longer to get advanced parole. You can make InfoPass appointment and see if the USCIS officer will grant an InfoPass appointment to get emergency parole. Back to you, sir.
Okay, let's go to the East Coast. Let's go to Dia in New Jersey. So Dia, some employers are considering downgrading their EB2 applicants to EB3 based on these new visa cutoff dates, and some employers are not. what is your understanding of what an employer should be doing, and what are you advising clients?
That's right. So let me start by saying that I'm not a big fan of the word downgrade. I think that's common parlance, but really there's no downgrading of anything going on. All we are doing is filing a new petition for EB3 category, right? So let's back up a little bit. Why are people requesting downgrades? The downgrade is being sought by foreign nationals who currently have EB2 approved petitions, and they realize that the priority date, while it's not current in the EB2 preference category, if they had the same priority date in EB3, they would be eligible for filing of adjustment applications, right? So these foreign nationals are now requesting their employers to file new EB3 petitions for them, such that using the older priority date from the EB2, they would be able to concurrently also file the adjustment application. So an employer can technically do this, and the way you do that is because the current regulations provide that if an employer has an approved I-140 for someone, the employer can refile or file a new I-140 petition for a different category using the same labor certification or the PERM, right? Because the labor certification or the PERM is really what takes time. It takes about 12 months today to start and complete one. So instead of filing a new PERM or labor certification, what an employer could possibly do is refile an EB3 petition, citing the fact that you already have an EB2 petition approved for the same person. And so many foreign nationals are understandably interested in filing these EB3 petitions now, because of the advancement in the filing dates. And also I just wanted to clarify, as I said, this is I don't think the correct word to use is downgrade. I think because you're not modifying or changing the existing EB2. You're just filing a new EB3 petition using the existing labor certification. Now, your question, Mr. Chug, as to whether an employer should be doing it or not. So that's a really difficult question to answer today. I know that many employers are debating, they're considering, they're weighing the options, and they're seeing should we do this, especially when they have a large number of employees who are requesting this, because we've done this in the past, but we really don't know how USCIS is going to be looking at it in the future. So if you want, I can talk a little bit more about the risks to this process and the actual process involved. So yeah. So
okay. So first tell me what is the process from downgrading the employees from EB2 to EB3?
Right. Yeah. So it is an I-140 petition. It is pretty much an I-140 petition being filed again. So the employer has to meet all the requirements that they would ordinarily be expected to meet for a regular I-140 petition, right? So you have to present a labor certification. The labor certification here is the one that was previously used for the EB2 filing. There is a specific exemption which allows for the labor certification to be used again, even if it is expired, provided it was used already for an I-140 petition, right? So once a labor certification is utilized to file an I-140 petition before it expires, and the I-140 petition is approved, then it kind of gains perpetual life. And so then you can use it labor certification again for a new filing, which is what we are doing with this, the so-called downgrade EB3 petition. Employer has to meet all the requirements, including presenting proof that the job offer is valid and bona fide, etc. The employer has to present evidence that it continues to operate and that it has the ability to pay. And this is very important, right? The ability to pay has to be established from the original priority date. So if it's been many years since the previous EB2 petition was filed, right? If it's been 7 years or so since the EB2 petition was filed, and today you're filing the EB3 petition, the employer has to show ability to pay the prevailing wage for all the intervening years. So that's an important point to note. And then, of course, the employees' qualifying documents, which normally would have been met at the time of the previous petition, so that really shouldn't be a problem. So all these things come together, and then you file this EB3 petition. And along with the EB3 petition, because now you're going to utilize the date from the EB2 petition, you include a cover note that the employee is eligible for concurrent adjustment of status, and you put in the I-485 application with all the attendant benefit forms that Deepika spoke about, like the EAD, the advanced parole, also the public charge document. So you're going to end up with a very bulky package at the end of it, and everything has to be in place. The important thing to note is also that the adjustment is riding on the I-140, right? So if for any reason the I-140 gets denied, then the 485 would ultimately get denied as well. So you want to make sure that you work with somebody who's experienced and who understands all the the issues involved. You also have to treat the I-140 downgrade filing as not just a simple filing. Treat it with all this the seriousness or the respect that an I-140 petition deserves, including proof of the employer's existence and ability to pay, all of that.
Okay, and how long is this process to convert from EB2 to EB3?
So the EB3 filing, once you have the option of doing it in premium processing, but there are certain limitations to requesting premium processing. So one of the requirements for requesting premium processing with an I-140 petition, as many of you might know, is that you have to show the original labor certification, which you won't have in this case, right? So because of that, I think most practitioners are going to recommend not to request premium processing and just do it in regular processing. Because if you request premium processing and USCIS denies, refuses to honor the premium request, you could end up with the petition, the entire package getting kicked back. And that's not a risk that you want to take in this limited window in October. So for that, I would say, my recommendation to clients at this point is just file it in regular processing. Once you file it, right? Once you file the I-140 petition with the adjustment application, you're good. You don't necessarily need an approved I-140 petition to be able to put in the adjustment application. All you want is to be able to file everything together. And you have to file an approvable I-140 petition with the adjustment application. The adjudication of the I-140 itself might take 5 to 6 months, or whatever that USCIS is going to take in the regular processing timeline. And the 485 adjudication, as Deepika before pointed out, once you file the 485, once you file the adjustment application, you are in the queue. But now you're going to be governed by Table A when it comes to adjudication of the adjustment application, right? Adjudication of the adjustment application results in you getting the green card, and that will depend on Table A and the priority date movement in Table A. So that's sometime hopefully not too far away.
And what happens if my EB3 is denied? Do I lose my EB2?
Yeah, that's again a good question, and I think that's what everybody's debating these days. So that that comes down to one of the risks associated with this downgrade, right? The fact is that USCIS has not really given definitive guidance on this. Historically, I'm sure we've all done the EB3 downgrades for Chinese nationals in the past, because for them too the EB3 priority date was moving faster than EB2. So we did a lot of downgrades for Chinese nationals in the past, and there were no issues. There were, I think, we didn't encounter any issues. But the question is whether the EB2 is revoked as a result of the EB3. We don't really know. I would say, based on today's regulations and the historical, at least our experience with USCIS, the EB2 should not be revoked. It should still hold good. And USCIS has not said anything to the contrary. But again, as everybody knows, it's now that there is going to be a big surge in the number of these filings in the month of October. It is possible that USCIS might change the way they view or interpret this. So it's I guess we can only hope for the best. And going by the current regulations, I would think that the EB2 should hold good. It's also possible that USCIS might come up with some guidance, right? Because now there's so much buzz around this and there's a lot of filing. So I would expect that there might also be some new guidance coming out soon.
Okay, any other risks if I downgrade from EB2 to EB3?
Right. The other, fairly common question now that we're getting is for somebody who's downgraded, right? Who's used the downgrade option and has filed an adjustment filing, right? Using the EB3 queue. So if you did a concurrent adjustment filing using the EB3 petition, and then subsequently you find out that now EB2 is moving faster, right? EB2 is more favorable. What do you do to get back into the EB2 queue, right? And so again, there's not a very clear path for that. Theoretically, we can take advantage of the option of interfile, right? So that's the USCIS term. When you want to connect an existing I-485 application with another petition, you can request an interfile. The problem with the interfile request is that there's no streamlined mechanism for it. And so you have to, do it by writing to USCIS, by maybe, raising a couple of service requests. And because there is no set mechanism for it, you need a number of follow-up efforts before it's done. At least that's been our experience so far. And I would expect that it's going to be similar unless CIS comes up with they come up with a process for the interfile.
Okay. That's great. So let's go to Carmen in LA. So Carmen, what are some things that employers and green card beneficiaries should consider for the future, given what is going on with the October Bulletin?
Yes, thank you. Well, first of all, let's not forget that we have a proclamation in place right now regarding those people who are outside the U.S. obtaining green cards. The presidential proclamation limits issuance of green cards at U.S. consulates abroad until December 31st, 2020, at least, unless this is extended. Also, the Department of State expects advancements in many implement-based categories in the coming months. Anticipated are rapid forward movements for India and China in EB1, EB2, and EB3. Another thing to consider is the fees and form changes were to happen on October 2nd, as Dia mentioned and Deepika. However, yesterday there was an injunction where they're putting a hold on this fee increase. This means that when filing your I-45s, you may be paying the lower amounts as they are in effect today on September 30th. We will keep a close eye and inform you of any changes or updates to any filing fees, if there are any in the future. So with that said, we can take some questions.
Okay. That is great. Okay, so I have a question, and any one of you can answer. The question is it possible to apply for an advanced parole without work authorization?
I could take that answer. Yes, you can. You can file for it, but now I want to just mention to you that if you were to be paying the higher fees effective October 2nd, which were in effect until yesterday, you would have paid an additional filing fee for that, right? You would have paid $590 for an advanced parole and another fee for the EAD. But now if the injunction is in place and you can file with the old fees, when you file an I-45, let's say an I-45 application, you pay one fee of $1,225, and that includes, regardless of whether you want the EAD or not, or the AP, you're going to pay $1,225 for the I-45, the biometrics, the EAD, and the AP. So there's no reason not to get it. Of course, if you're paying the higher fees, then of course you'd want to save, some money, especially since all this is very costly.
Okay. What happens to the H4 dependents when you adjust status?
So And the question, I'll take it. So what happens with H4? So I'm assuming that, you know, when you have an I-485 filed, you're gonna be, you know, filing I-485, getting an EAD and AP. The H4 status continues to be intact. Now, like I mentioned before, if you use the EAD and you're on H4, your H4 status is, of course, gone. Poof, it goes away. There are ways to get it back if you want it, but you got to go back to the consulate to get a visa and come back into the United States.
All right. What about, so this is a question that's being asked by 10 people. What if I convert to downgrade to EB2, EB3 rather, and then EB2 gets faster in the future, then can I go back to EB2?
Right. I can expand on it a little bit more. I think I touched upon it when I was speaking. So what if you want to get back into the EB2 queue, right? So there's, you know, two issues to be considered. One is, does the EB2 still hold good? And we assume, in the absence of any contrary guidance from USCIS, we assume that the EB2 would still hold good. And so presumably you can utilize that, you know, to get your green card if things start moving in the EB2 category later. Again, this is, you know, as of, you know, the regulations and, you know, the practice as we see today. And then the mechanics of getting back into EB2, right? So right now, your adjustment application is riding on the EB3. And so for you to be able to get back into the EB2 queue, you have to raise an interfile request with immigration, with USCIS. And as I said, there is no you know, real mechanism. There's no streamlined process for that at the moment. You have to normally do it through a service request or by, you know, writing to USCIS, and they will get to it, you know, when they get to it. There's no timelines or anything around it. In the past, when we had these interfile requests, you know, we would have to, you know, keep writing and calling, and sometimes it would take 6 months, you know, to get USCIS to notice and, you know, actually connect the two files and take action. So, but as I said, you know, with the number of filings now, I would not be surprised if, you know, if USCIS set in place, you know, a process for this, for the interfile request.
So Dia, while I have you, there's a lot of questions about, I worked for an employer and they filed my I-140, but I left them and joined another company. Yeah. Now the first employer who filed the I-140 is willing to hire me and do the all the processing for the 485 and I-140. When do I have to join the old employer back?
Right. So you can, yeah, the old employer, let's say ABC employer, can sponsor or can support the adjustment filing if the job offer is really valid and if it's still, you know, if it's still good, right? You know, nowadays we get a lot of RFEs on the good faith nature of the offer. Is the offer still genuine? Do both parties still intend to take up this position if the person gets the green card, etc.? So we see a lot of RFEs around that too now. So I would, you know, I would be a very, I would make sure that I have all the documentation in place before going back to the old employer and filing an adjustment application based on their sponsorship. So they would give you an I-485J. That's the form that confirms that their job offer is still valid. And as you said, yeah, you can do that. And now the question as to when you should join that employer. So there's no obligation to join that the sponsoring, the petitioner who signs the 485J right now, right? That obligation, and I don't know if you should call it an obligation, but once you get your green card, if you haven't worked with that employer for at least some time, there could be red flags at the time of your naturalization application, right? So, you know, it would be good to keep that in mind and, you know, show that there's at least a small amount of a short period of time. I would say at least 6 months, that you've 2 to 6 months. I think that's generally what people recommend, that you should have worked with that with the sponsoring employer after receiving your green card.
Okay. So Deepika, I have a question for you. And let's look at it from a broader point of view. So the question really is that the name on my passport does not match the name on my birth certificate. How do I handle this? So let's talk about all such problems. Name and date of birth, and date of birth is different on some documents and names different. What is the overall suggestion you have for clients?
So Navneet, to answer that question, procedurally, all information, biographic information should match. In case you have a situation where the name on the passport does not match the birth certificate, then that birth certificate is actually not yours. And if the name is totally different, we have to have evidence as to why the name is different. We will have to support documents, submit supporting documents to, kind of to link the problem. And I guess for such kind of situations where things are different on each document, it's best to work with with a professional to understand what can be done and what documents can be submitted in support of such a situation. But just to add to my point, the government of India and the states and the municipal and the death registrar offices are issuing birth certificates if the birth was registered, and they have old records. But whatever old record is there, that's the name which is coming up on the birth certificate. So it's good to cross check with them and see what can be done to amend the birth certificate and what processes, what is the process they follow to make any changes to the existing birth, information they have in their database. But yeah, we can work on case-to-case basis and come up with some solutions.
Okay, Deepika, one more question for you. Can I-140 for the downgrade and 485 be filed at the same time?
Yes, so the concurrent is allowed, but as Dia has mentioned that it has some calculative risks. But yes, the downgrade of the I-140 as well as the 485 can be filed concurrently.
Okay, Carmen, a quick question for you. I am waiting my I-485. Can I get rid of my H-1B?
So the answer to that is, if you have an EAD already issued through the I-45, yes, you could, start working on the EAD, but there are risks, as we discussed. If you start using the EAD, your H-1B is gone, and if your I-45 is denied, you will have no status. Therefore, it's a bit risky to not continue to extend your underlying status. It's best to not do that, and just continue to use your H-1 status until your green card is approved. But if you have issues, where you have to use the EAD, then you have to understand that there are risks involved. If your I-45 is denied, you will have no status.
Okay, and can I file for the EAD? I have an approved I-140. Can I file for an EAD even if I have not filed the 485?
No.
Okay.
You can file for the H4 EAD based on the approved I-140. But for the primary applicant himself or herself to qualify for an EAD, you have to have an I-485 pending.
Okay, so I have one last question and then we go. And then we'll redo this webinar on October 14th. So please tell your friends who couldn't join us today to join us on October 14th. And if you have more questions and you need more information, join us again on October 14th. So last question for you, Dia. Once the adjustment of status is filed, do children age out at 21?
Yes, excellent question. So that's something that needs to be looked at on a very case specific basis, because the calculation for CSPA, the Child Status Protection Act, basically what that says is that you can deduct the time that so in this case, the I-140 petition, right? So you can deduct the time that an I-140 petition was pending with USCIS. You can deduct the time from the child's age. And if after the deduction, the child's age is under 21, then he or she will qualify for the adjustment benefit with the parent. So that's simple enough. But the problem is that this calculation doesn't really help somebody who's filing using the table B, which is what we are doing here, right? So the CSPA calculation is done on at the time that the date that the parent's priority date becomes current according to table A, right? So filing using table B will not really lock in the date because it's the priority date is not really current in that sense. It's not really current for final action at this time. So if you have a son or daughter who is very close to aging out, and you are hoping to just file for their adjustment in October, thinking that it'll lock in their age, you should make sure to discuss the case with an experienced practitioner and confirm that your child will really benefit.
Okay, thank you so much. Thank you, Dia. Thank you, Carmen. Thank you, Deepika. You guys are awesome. To the audience, any questions, please feel free to send us a question, info@chil.com, or to any other panelists. Stay safe, and we'll see you soon. Thank you so much.